Ready, start. When any person has been sentenced to punishment for an offense, appropriate government may, at any time, without conditions or upon any conditions which the person sentenced accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. Full stop. Whenever an application is made to the appropriate government for the suspension or remission of a sentence, the appropriate government may require the presiding judge of the court before or by which conviction was had or confirmed, to state his opinion as to whether the application should be granted or refused, together with his reasons for such opinion, and also to forward with the statement of such opinion a certified copy of the record of the trial or of such record thereof as exists. Full stop. If any condition on which a sentence has been suspended or remitted is, in the opinion of the appropriate government, not fulfilled, the appropriate government may cancel the suspension or remission, and thereupon the person in whose favor the sentence has been suspended or remitted may, if at large, be arrested by any police officer, without warrant and remanded to undergo the unexpired portion of the sentence. Full stop. The condition on which a sentence is suspended or remitted under this section may be one to be fulfilled by the person in whose favor the sentence is suspended or remitted, or one independent of his will. Full stop. The appropriate government may, by general rules or special orders, give directions as to the suspension of sentences and the conditions on which petitions should be presented and dealt with. Full stop. Thus, the power conferred on the appropriate government is of remitting the whole or part of the punishment to which an accused has been sentenced, with or without conditions. Full stop. There is also a power vested in the appropriate government to suspend the execution of the sentence. Full stop. However, we are dealing only with the power to remit the whole or part of the sentence. Full stop. The power under section 432 of the CRPC is circumscribed by section 433-A. Full stop. It provides that where a sentence of imprisonment for life is imposed on conviction of a person for an offense for which death is one of the punishments provided, or where a sentence of death imposed on a person has been commuted under section 433 into one of imprisonment for life, the appropriate government cannot grant remission unless the convict has served at least 14 years of actual imprisonment. Full stop. There is an identical provision in section 475 of the BNSS. Full stop. This is an embargo on the power of the appropriate government under section 432 of the CRPC. Full stop. We may note that the power of the President of India under Article 72 of the Constitution of India, within bracket for short, single inverted comma, the Constitution, single inverted comma, close bracket close, and the power of the governor under Article 161 of the Constitution to grant pardon, commute the sentence, or remit the sentence remains unaffected by section 433-A of the CRPC or section 475 of the BNSS. Full stop. In addition to the power under section 432 of the CRPC, there is a power vesting in the appropriate government under section 433 of the CRPC to commute the sentence. Full stop. There is a similar power under section 474 of the BNSS. Full stop. Commuting a sentence is independent of the power to remit a sentence. Full stop. We are not dealing with the power to commute sentences. Full stop. The first issue is whether the power to grant remission can be exercised without the convict or anyone on behalf of the convict applying to the appropriate government for a grant of remission, full stop. The second issue is about the nature of conditions imposed while granting remission, full stop. The third issue is whether there can be automatic revocation of remission granted to the convict if he commits a breach of the terms and conditions on which remission is granted, full stop. Lastly, another question is whether there is a requirement to record reasons while rejecting applications of the convicts for grant of permanent remission, full stop. Subsection within bracket 2 of section 432 of the CRPC and subsection within bracket 2 of section 473 of the BNSS contemplate an application being made for grant of remission, full stop. There are two decisions of this court dealing with the requirement of making an application, full stop. The implementation of the policy for premature release has to be carried out in an objective and transparent manner, as otherwise it would impinge on the constitutional guarantees under Articles 14 and 21, full stop. Many of these life convicts who have suffered long years of incarceration have few or no resources, full stop. Lack of literacy, education and social support structures impede their right to access legal remedies, full stop.